Hi, I'm Tyler Nims from the Cambodia Tribunal Monitor. I'm here at the offices of the Documentation Center of Cambodia with John Ciorciari, who is a professor at Michigan, at the University of Michigan, and also a longtime advisor to DCCAM. John, can you tell us a bit about your background and how you became involved with Cambodia?
Sure. I went to law school in the late 1990s, and I was practicing in a firm. I became interested in human rights because I took a number of political asylum cases in New York City. And after I developed that interest, I decided I wanted to take a sabbatical from the law firm and to do something overseas. Cambodia was a country that I was interested in because I had studied the region as an exchange student. And I managed to come into contact with Yale University Professor Matt Kiernan, who was instrumental in setting up DCCAM in the mid-90s. He recommended that I get in touch with Duch, who, as you know, is our director now. I phoned Duch as an associate at this New York law firm, told him I was interested in volunteering, and after we communicated for a while online, I traveled out to Phnom Penh and stayed here for about 5 months. That was in 1999, and I got hooked, and I've been involved ever since.
John, as you know, on Monday the court handed down its opinion or its judgment in the Duch case. What are the positive aspects of that judgment?
To me, the biggest positive aspect of the Duch verdict is its ability to communicate to not only the court but also victims and survivors the seriousness with which the court took due process norms in this case. So it's asking a lot of any court to conduct a fair trial when the defendant is someone who is well known historically to have committed terrible atrocities and who's widely perceived by the public to be guilty, who's even acknowledged some measure of responsibility. This trial was conducted, in my opinion, more or less fairly. The verdict goes through a series of different considerations on the types of competing interests that the court considered when it was issuing its sentence. It had to think about the seriousness of his crimes, which are obviously staggering. It also had to think about his past human rights violations that he suffered while he was illegally detained. It had to think about the incentives that courts have to promote openness and truth-telling on the part of defendants. And it also looked to his contrition, his expressions of apology. And in trying to balance all of those different interests, it came out with a term of 30 years that I think is roughly in line with international precedent that was not entirely unreasonable. So in terms of the type of reasoning that it used to get to its conclusion, I think that the court did quite well, and I also think that the entire trial was perhaps not an ideal model of a fair trial, but not far off from that.
The court credited Duch with 5 years for the time he spent in military detention. What are your thoughts on that issue?
I don't have strong feelings about the amount of time that should have been subtracted from his sentence. So as you referred to, the court started with a number of 35 years for the sentence, reduced it to 30 on that basis. I definitely think that the court needed to credit him with something because of his illegal detention. If a tribunal like this is to have any effect at all in advancing the rule of law in a country like Cambodia, where due process rights are so often neglected, it has to practice what it preaches. And in this case, Duch was very obviously detained illegally because Cambodian law had a 3-year maximum detention. So after 2002, when the 3-year time period expired, he was detained illegally at that court. That's a serious, serious breach of his rights. Even though he's an odious defendant, even though he's committed terrible atrocities and has acknowledged them, the court had to make that meaningful. And so the 5 years to me is not so important as the acknowledgement of the importance of that illegal detention. And the fact that the overall sentence, be it 30 years, be it 35 or 40 years, was of a length that made that sentence reduction meaningful.
Many Cambodians have expressed their dissatisfaction with the length of the time that Duch will spend in jail, which I believe is about 19 years. Do you share that dissatisfaction?
I share it a little bit. I think that Duch should probably be put away for a term that will more certainly last for the duration of his life. The current 19-year time frame would, at least in theory, allow him to walk free when he's 86 years old or so. So I would have made it a little bit longer. But I wouldn't have made it too much longer because, as I said a moment ago, the court has to somehow address the fact that his rights were violated. It also has to somehow account for the fact that alone among Khmer Rouge officials at any level of seniority, Duch has expressed some measure of remorse and has acknowledged that he committed these crimes. Those are very, very important things for the court to weigh, and it only can give them weight if the sentence is a length short enough so that it has some meaning in relation to Duch's life expectancy. If the ECCC had sentenced Duch to 150 years in prison and then knocked off 10 or 12, it would be a meaningless gesture. By having a sentence of 35 years and then reducing it and accounting for time served, which I think is also entirely appropriate, the court actually gave some substance to its defense of these due process norms.
Some commentators have criticized the way that the court treated the civil parties. What's your take on that issue?
I'm more inclined to share that criticism. I think that the sentence issue, there's a range of reasonable outcomes, and they're at the lower bound of what we call a reasonable outcome on this. But with respect to the civil parties, I think that the court's verdict was really lacking. Civil parties, as you know, were an innovative aspect of this proceeding. The ECCC was established and negotiated in the mid-2000s, the middle part of this decade, when civil party mechanism had been established but not yet really tested in the International Criminal Court. So this was a very, very popular feature of the ECCC, and it was something that attracted a lot of donor interest and support. And therefore, from a certain perspective, it's been a kind of sacred cow in these proceedings. At the same time, it's proved problematic because it makes the proceedings longer. It, in some cases, resulted in civil party lawyers making arguments that were redundant with the prosecutors or that in various ways were in tension with what other civil party lawyers were saying. So it's clearly been difficult, it's problematic. For that reason, the prosecutors, some of the judges, some of the court officials have looked at this civil party mechanism as a real source of difficulty and trouble and have sought ways to limit it. And in fact, they have limited it significantly in case number 2, so civil parties won't play such a prominent role. The problem, as I see it, is that by the time of those decisions, by the time that the court decided to limit civil parties' roles in case number 2, the train had long since left the station on case number 1, civil party participation. And so there were these 90-some civil parties whose hopes and expectations had reasonably adjusted to the reality that they were a big part of this process and that they were at least theoretically entitled to collective and moral reparations. I don't have enough information to assess whether the roughly 24 civil parties who rejected in the Duch verdict, whether that was legitimate or not. I would need to know more about the specific information furnished to the court. But I can say that I found the court's award of civil party reparations very lacking in imagination. The award was to publish the names of the civil parties in the verdict, at least those who were found to have substantiated their claims, and also to publish excerpts of Duch's statements that expressed responsibility or contrition. That's even below the sort of minimum that I would have said is acceptable for civil party reparations. The court rightly pointed out that it doesn't have authority to dictate to the Cambodian government what the Cambodian government should do, such as building new stupas or setting up health clinics, but there are other things that the court could do. The court could certainly provide slightly greater acknowledgement of victim sufferings within its own compound and its own building. There could be engraved names somewhere in that particular complex where the court could issue suggestions or recommendations in various forms. The court could express its support for civil society efforts that were already underway. So I just think it lacked imagination, and that it had the effect of making victims feel that they had been dismissed or even disrespected. And that's a real shame, because as I say, although civil party participation has been problematic at this court, civil parties were included in case number 1, and the court had a responsibility to deal with them sensitively.
Beyond the civil party jurisprudence, what do you see as the consequences of Monday's judgment for the second case and any subsequent cases?
The hope is that this relatively lenient sentence is going to incentivize the case 2 defendants to break ranks and express either responsibility on their own part and contrition, or to impugn other defendants, because the documentary evidence against these 4 case 2 defendants is not as overwhelming as the documentary evidence was against Duch. I'm not sure that that will actually have such a strong effect. And one reason is that the case number 2 defendants are all much older than Duch, and I don't think they could reasonably expect to receive sentences, if convicted, that are short enough that they would outlive those sentences. That's one possible outcome. Another possible outcome, of course, is that Duch's own sentence will incentivize him to provide information in case number 2 that will be useful. And I suspect that one reason why the prosecutors requested 40 years for Duch and not a much longer sentence is that they're hoping that he will be helpful in that regard. Again, I'm not sure. I don't have inside information on that. My inclination is to believe that Duch already has ample incentive to share information in case number 2, simply to support the argument that he's made publicly throughout this trial that he wasn't the one ultimately most responsible, he was just following orders. So I'm not sure that he needed that incentive in order to share his information. And more broadly, the implications of this for case number 2 coming forward. On the positive side, I see that, again, this was a case against Duch that respected basic principles of due process. That sets the bar reasonably high for case number 2, and I hope the court follows the same types of principles in that proceeding.
Picking up on that theme, what are your hopes and concerns for the future of the ECCC?
My hope is that the court is able to conduct trial in case number 2 efficiently and effectively enough that justice is meaningful with respect to those 4 senior officials. It's entirely possible that one or more of them could pass away, or at least be in such ill health that their trials become meaningless before the end of the proceedings. To me, this is by far the most important case and most important set of defendants the court will see before it. If there are subsequent cases, 3, 4, and 5, they're going to be much less important in my view than case number 2. So that's my number 1 priority. I think that the court has put itself in a difficult position because of the elapsed time to be able to get this done, but I think it still has a reasonable shot. My biggest concern is about victim participation. That's understandably the big concern, because the hardest thing to do. It's a lot easier to hold a criminal trial and to hold a couple of people accountable than to try to satisfy the needs and aspirations of millions of victims, or even thousands of civil parties. And I think that, as we discussed a moment ago, the court found that challenging in case number 1. It'll be much more so in case number 2, because the offenses that are alleged against these defendants are so much more numerous and so much broader than the ones that were alleged against Duch. At this stage, I think that we see certain trends that are positive with respect to the court's outreach efforts. They've done a better job at educating the public about what's going on. On the other hand, as we discussed, the civil party mechanism is up in the air. It's been very problematic. There's also news today that the head of the victims unit has been replaced. And so there are a lot of moving parts in victim participation that are going to be a challenge. The court can't do it alone. It needs partners like ECCC and the other civil society organizations and the government to help. That to me will be the other main key, along with conducting a sound case number 2, judging whether this is ultimately a success.
Well, thanks for talking with us today, John.
You're very welcome. It's a pleasure.